We are live. All right, good morning, everyone. Good morning. All right, we're going to call the October 2nd, 2023 San Diego LAFCO meeting to order. We have a roll call, please.
Commissioner Desmond?
Here.
Commissioner Anderson? Here. Commissioner Becker? Here. Commissioner White?
Present.
Commissioner McKenzie? Commissioner Willis? Here. Commissioner Whitburn?
Here.
Commissioner Vanderlyn is absent. Alternate Commissioner McCann?
Present.
Alternate Commissioner Drake? Here. Alternate Commissioner Von Wilpert is absent. Alternate Commissioner Mathis?
Present.
Alternate Commissioner Mathis will vote in place of Commissioner Vanderlyn, who is absent, and there is a quorum with 8 members present.
All right, thank you very much. So we have no one participating remotely today?
Correct.
Good, okay, good. One less screen to look at. Okay, good. All right, for the agenda review, Keen, do we have any updates for today's agenda?
We do, and the update, so we have an update with respect to some accommodations as well as some supplemental communications. So on the accommodations, Vice Chair Whitburn does have a hard stop at 9:20, so our suggestion is that you take some things out of order. In particular, Commission, if at the end of our lone public hearing item 6A, if we pivot there, go into closed session to take up 10B and 10C, which happens to be my performance review, then come back into open session and carry on with the business calendar, which then would wrap up into a final closed session, item 10A. Those are the requested changes to the agenda. And then finally, we do have a few supplemental communications, all with respect to item 7A, and staff will address those when the item comes up.
All right, thank you. The other thing we're taking out of order is the Pledge of Allegiance. So, Mr. Mathis, could you lead us in the pledge? Thank you. All right. I see I've got speaker slips here. I have a speaker slip for Mr. Kennedy. Do we have any other public comments for not on today's agenda? Let's see. First of all, I guess we'll just go right to... No, wait a second. There's a lot of stuff out of order today. Do any commissioners have any updates or changes to the agenda? Nope? Okay, good. So we'll move into public comments. We do have Mr. Kennedy. Would you like to come before us with public comment?
Yeah, thank you, Chair Desmond. As many of you know, about 9 years ago, I came before this body first with a slightly different thing than we were doing lately. It was when Fallbrook was trying to dissolve Rainbow. Thankfully, we resolved that and then become good friends since then and had another thing. But I'm not here to talk to you about that. 8 years ago, I was elected to the Special District Advisory Committee by the Special District of the County, which was a great honor to me, and I got re-elected 4 years later. But Wednesday is my last day at Rainbow as the GM, and so I'm retiring. So I have to resign from the Special District Advisory Committee, and I thought no better way than to come here and thank all of you on the commission and your predecessors and even the prior executive officer for the support they've given the committee, which I think does great work. I think you're going to hear about that in 7A a little bit, and I guess I'm going to be conscripted to speak on 7A as well later. But I just wanted to thank you all for the support you've given all the special districts and for the work you do here at LAFCO, because LAFCO really does matter. So go to LAFCOmatters.com, smash that contact button, and then hopefully I'll be working with you guys again in the future. So I'll give this to I'll give it to Priscilla. Thank you.
Well, thanks, Mr. Kennedy. Appreciate your time and good luck in retirement, and I'm sure we'll see you again. Okay, so will you have anybody online or calling in for a non-public agenda for comment?
None.
None? Okay, thank you. All right. Okay, that moves us to the consent calendar, items 5A through 5H. Are there any items that people would like? We've got a couple of speakers on some, well, at least one of the items. Any of the commissioners have any items they want to pull or have for discussion? Hearing none, seeing none. We do have a speaker on 5C. Tom Kennedy. I knew we'd see you again.
Yeah, so, I just want to point something out. This is actually a development that's near my house in the city of Escondido. And I was at the city council meeting, the planning commission on it. Didn't get what we want, but the thing from LAFCO's stand here is there's nothing really controversial from LAFCO's standpoint, but I know on your work plan was to look at your islands annexation policy. And in this particular part of the city of Escondido, near where I live, it's pockmarked with all sorts of different little county islands, which makes for an uneven experience for those of us who live in the area where there's a part of the city where there's sidewalk, and then it's the roads all changed, and it's still this all over the place. And so for this particular one, there's this parcel, and then there's 4 or 5 other parcels in this little island. And my recommendation is to have staff, through the island annexation policy, look at a more broader look at these things rather than piecemealing one parcel at a time. It makes for very difficult and disjointed planning efforts, both at the city level and the LAFCO level, that in the future, if someone wants to come and, shave off one little parcel just to meet some acreage requirements to get a massive list of exemptions and stuff that are required for the density bonuses, that LAFCO would say, hey, well, we should also clean up the rest of this island at the same time and try not to just have a death by 1,000 pinpricks here. So those are my comments moving forward to have the staff dig into the island annexation policy. Thank you.
All right. Thank you. Do you have any speakers online for the consent items? Erica?
None.
None? Okay. All right, so is there a motion for the consent?
Actually, it looks like we have a late entry.
Can I turn in a speaker slip somewhere?
What item, which item you?
5C, right?
Oh,
5C? Sure. You want to give it a do, and if you could state your name for the record, that'd be great.
Yeah, Dylan Bird. Okay. On item 5C. I just wanted to point out on the parcel that you guys are considering today, the annexation that Mr. Kennedy just spoke about. If you look at the island, there's a county island there. This parcel, it's not like it's touching on one border. 3 of the borders are contiguous to the city. There's only one side that's contiguous to other county property. So if you look at the island, it makes a lot of logical sense to carve this part out and take this into the city. So I just wanted to point that out to you guys. That's it.
Thank you, Rick. So that
Because you got 7A written on your speaker slip. You want 5C?
5C, I'm sorry.
Okay. All right, good. All right. Thank you, Dylan. All right, from the commissioners, is there a motion on this the consent calendar?
I'll make a motion.
Okay, we have a motion, Mr. Willis, second by Commissioner Willis, and second by Commissioner McKenzie. If there's no other discussion, have a roll call vote, please.
Commissioner Anderson?
Aye.
Commissioner Becker?
Yes.
Commissioner Desmond?
Aye.
Commissioner McKenzie? Aye. Commissioner Willis?
Aye.
Commissioner Whitburn?
Yes.
Commissioner White?
Yes.
Commissioner Mathis?
Yes.
So there are 8 in favor, 0 opposed. The motion passes.
All right, thank you. Oliver, quick question for you. You have 6B written down here. You want 7A. I was going to say there is no 6B. So I just want to make sure you weren't part of the consent calendar. All right. Okay. All right. So we have a motion and did we do the roll call vote? We just did. Okay. Damn. All right. I'm getting old. All right. So it passed. So we're moving on to the consent item we're done with. Public hearing number 6A. And after that, we're going to do in closed session 10B and 10C. So 6A, we've got, is there anybody that has any ex parte disclosure? Any commissioners report for 6A? None? Okay, with that, King, you want to kick this item off?
I will, and in this era of COVID, I'm going to ask our remote participant, Carol Neiman, to give us the staff presentation, and I will help out with any questions from the commission. But Carol, if you're available, please proceed.
Can everybody hear me?
Yes.
Yes.
Okay, perfect. Good morning, Chair Desmond, Vice Chair Whitburn, and fellow commissioners. For the record, Carol Analyst with San Diego County LAFCO. Before you today is a proposal that we received by landowner petition that is seeking LAFCO's approval today to annex approximately 35 acres of unincorporated territory to the San Diego County Sanitation District. And as I will detail in a bit, there's a unique policy issue that underlines the Commission's consideration of the proposal on the topic of timing, and the reason staff has asked for a continuance at the last meeting so that we can do a little more digging. And this intrigue aside, the purpose of the proposal is to extend public wastewater to the affected territory to accommodate the expected placement and connection of a 32-foot by 8-foot restroom trailer, given the foreseen expansion of truck activity in the area with the pending opening of the East Otay Mesa Port of Entry in 2024. Now, this is in addition to the already open and heavily trafficked Otay Mesa Port of Entry, which is located approximately 4 miles away from the affected territory. And now I would like to ask Stu if you can just pull up the 2 slides that I have so that you guys can all get acquainted with the affected territory, and hopefully that will be shown soon. But on the screen you should see a map of the entire affected territory, which consists of 2 parcels that are presently undeveloped with light surface improvements and fencing that serve its current use as a short-term staging/waiting lot for commercial trucks. The parcels are located.
Can you hold on 1 second? We're just waiting to pull up the map.
Okay.
That's 7A.
I don't think I received that PowerPoint, Carol. I'm sorry.
Okay.
Well, let's, Carol, do you know what page in the agenda packet the map is?
It should be, you can see the vicinity map, which should be page, I think, 7 or 8 in the agenda report. And the inset map should be probably page 3 or 4,
126.
which is the first slide.
Okay.
Sorry, I don't know the exact pages as they are on the agenda report.
So commissioners, if you will take a gander to page 143. So
Okay,
Carol,
thank you so much.
yeah. go
Okay,
ahead.
I will continue. Sorry about that hiccup. So, as I was mentioning, the parcels are located in the unincorporated community of East Otay Mesa, and they lie southwest of the Otay Open Space Preserve. And in the vicinity map, you should see a map of the 2 subject parcels in relation to the San Diego County Sanitation District's jurisdictional boundary, which you should be able to see that the parcels lie just outside of the sphere. So, in addition to the annexation, this proposal necessitates a conforming sphere of influence amendment to include the entire affected territory in the district's boundary. And as detailed in the agenda report, the landowner has access to the district's collection system, which is located immediately south of the property on the public right-of-way of Camino de la Fuente. They obtained access through a lateral sewer main extension. And the district's most recent municipal service review prepared by LAFCO staff was done so in 2019, which, as a reminder for the Commission, a new municipal service review is not required given the last one was completed within the last 5 years. And to that point, staff has found that the San Diego County Sanitation District has both the adequate capacity and the financial standing to accommodate the change of organization without any material deficiencies. These findings are based on the proposed project accounting for less than 0.082% of the district's available treatment capacity, as well as the district having favorable liquidity and capital levels. As further documented in the agenda report, the proposal is justified under both adopted policies and statute, with one exception involving the timing of the jurisdictional change. And in this particular case, the timing of the change would best sync with the applicant already having the permit to place and connect the restroom trailer in step with the proposal application. However, staff has found that deferring annexation to the actual project creates obstacles for both the landowner and their lessee, given the former is responsible for securing annexation and the latter is responsible for securing the wastewater discharge permit with the district. This, coupled with LAFCO's provision in statute to get involved with land uses or development, staff believes that the viable solution is to require the landowner or the lessee to submit a complete permit application with San Diego County Sanitation District that aligns with their planned placement and connection of the restroom trailer. And just so the Commission is informed, the applicant is agreeable to this term, which is documented in their attestation letter that we received on September 25th. Said letter has been provided to you within attachment 2 of the agenda report. Now, this conclusion highlights and underscores staff's recommendation to proceed with approval of the proposal today as submitted, along with a conforming sphere amendment to the San Diego County Sanitation District. It is also further recommended that the Commission waive protest proceedings, along with making exemption findings to comply with CEQA. And with that, I would like to go ahead and conclude my presentation and also let the Commission know that the applicant's representative, Diane Kerma, should also be present today at today's meeting, or at least I hope she's present to help answer any questions. But I am certainly most available to answer any questions as well as staff. Thank you for your time. This concludes my presentation.
Well, Caroline, thank you very much for a very detailed presentation. Appreciate it. Any commissioners have any questions for the presenter? On this
You need a motion?
Yeah, wait a second. Let me find out if we have any speakers. Okay. Do we have any speakers, Erica, on this item? Either online or in person? No. Okay. All right, great. Mr. Anderson, you got a motion?
No, I was just asking. No.
So is that a motion for alternative number 1?
Yes. No, yes, I just agree.
Okay, so that is a motion by Supervisor Anderson, a second by Commissioner McKenzie. All right. Any other discussion, comments? All right, roll call vote, please.
Commissioner Anderson?
Aye.
Commissioner Becker?
Yes.
Commissioner Willis? Commissioner Whitburn?
Yes.
Commissioner White?
Yes.
Commissioner Mathis?
Yes.
So there are 8 in favor, 0 opposed. The motion passes.
All right, thank you very much. All right, now we are going to go into closed session. So we apologize to those here waiting to speak on item 7 and beyond. We'll get back to that as soon as we can. So we're going to ask public to leave and go into closed session items 10B and 10C. All right, thank you. Holly, do we have any report out here from closed session?
No, on items 10B and C, there was a general discussion. There was no vote. Any action taken regarding the EO's contract will be taken up in public session 7C.
All right, thank you. Okay, so we're moving on. We have 3 business items here today, 7A, B, and C. Beginning with 7A. So do we have, Keen, do you have anything to start us off on 7A?
We do, and I'm going to ask Carol if you are available to get us started, and then if you'd be kind enough to pitch it back to me at the end, I have some thoughts as well. So go ahead, Carol.
I apologize, but I didn't hear anything.
Oh, I apologize. So I said, so Carol, can you hear me now?
I'm still can't hear you.
Well, let me
Got my 7A.
do, if she can't hear us, I can go ahead with the presentation.
Yeah, I can hear you now. Thank you.
Okay, Carol. Well, so with the anticipation now building, if you'd be kind enough to start us off on 7A, and then at the end, if you pitch it to me, I'll offer up some thoughts, and we'll go from there. Thank you.
We can't hear you.
Carol, is your mute button on? Okay, hold on.
Can we get rid of that line across?
It's a new thing, and I've never seen it, and I have to Google on how to do it. We're testing something new.
You just can't hit a button and,
No. I wish there was a little X button for me to close that window. Carol, can you still hear us?
can you move it? Okay.
All right. Well, tell you what. Let me get the show going, and then Carol, you can help me if my mind goes blank. But before the commission is a returnee. So if for those who were with us back in November of '22, your staff brought a draft policy on out-of-agency services. Now, keep in mind, Commission, one of the many regulatory tasks that you are tabbed by the legislature to oversee is this dynamic. There are occasions when cities or special districts have reason to want to extend services by contract or agreement beyond their jurisdictional boundaries. Now, of course, keep in mind, 99% of the time, we would like to see those come in the form of annexations, but there are those opportunities in instances where politically or due to geography, there are these circumstances where cities and districts want to provide services by contract beyond their jurisdictional boundary. And so, beginning in 1994, your former colleague, Mike Gotch, who was once a LAFCO EO and then later city council member and then an assembly member, took all of the lessons that he learned at San Diego LAFCO, and we got elected to the assembly. He created this statute, 56133, which says, again, among other things, a city or district must first come to the LAFCO, request and receive written approval to be able to provide a service by contract outside their boundary. And in turn, the legislature gives you two kind of broad limitations on how you can go about an approval, right? So if the area that is part of the preferred or proposed service is within that agency's sphere of influence, well, the legislature says, okay, Commission, you can go ahead and approve with or without conditions so long as you find that it's going to be in anticipation of a future annexation. Okay, so fair enough. It gets a little more tricky if that affected territory lies outside of the sphere of influence for that agency. And in those cases, the legislature says, well, you can still go ahead, LAFCO, and approve that contract, but you need to make a public health or safety finding, okay? Now, whatever criteria you want to make, Commission, in making that finding, that's up to you, but that's the threshold. So, starting in 2001, this bill got reimagined into the rewrite of Cal-LAFCO or LAFCO law with a grandfather date, as well as some exemptions. The grandfather date is anything that was occurring before January 1st, 2001 is exempted. And then there are a handful of exemptions that the legislature has detailed, such as contracts between two or more public agencies where the service is a equal trade-off for something that is already being provided. Some gray there, and I'll come back to the gray. So, over the next 20 years at this LAFCO, outside service contracts really weren't on our front burner because we were still, for the most part, either not aware of them, they weren't happening, whatever the case may be. But starting in 2016, three kind of seminal events led us to want to draft a policy for you. In 2016, the city of Coronado sued this commission because at the time, your executive officer exempted an activity that the city of Imperial Beach was performing. City of Imperial Beach was the wastewater provider to a Navy SEAL station that happened to be in Coronado. There was an request to extend the wastewater line. At that time, your EO said, well, I believe that it's exempt because it was established before January 1st of 2001. Coronado said, no, but it's an extended use, so it triggers a whole new review. At the end of the day, the case got settled, but one of the key tenets was the judge in the preliminary documentation indicated that the LAFCO EO and the commission by extension was well within their authority to decide what is and what is not exempt. Fast forward a couple of years to 2019, we have a resource conservation district who started self-exempting themselves, believing that they had contracts with another public entity that didn't need to go to LAFCO. Turns out those contracts that Mission RCD was engaging in were not, in your staff perspective, did not qualify for exemption, and the very painful process of trying to unwind contracts that had already been executed ultimately led your staff through the commission to issue a cease and desist order against Mission RCD. And then last but not least, just a few months ago, we had a request from a healthcare district on the premise of addressing a public health or safety issue. Palomar was asked by 2 community clinics to provide source laborists and OBGYN services to patients at clinics that were outside Palomar's boundary and sphere. Your executive officer did make use of the one provision you currently have on the books, which is to delegate that kind of authority. But in doing so, we certainly illuminated there was an issue with both the timing and the process of how your executive officer makes that decision and whether it should be directly rerouted to the full commission. So that's the context. So November 2022, you get a draft of the policy that's before you. You say, for more or less, go forward with your public review and come back. We've done about 8 months of outreach. We've had a couple of meetings with your cities and special districts advisory committee on the topic, and now we come back to you today with a new and approved update. It's still a draft, but it's an update to the draft. What we would ultimately like you to do today is give us a second round of feedback before we tighten up and conclude the outreach and hopefully come back to you for action as early as December or January this year. Now, there are a couple of key items that are reflected in this draft, and at the wise recommendation of Commissioner McKenzie, all of you should have a track change version of the draft policy before you. The track changes are those, or the differences from what you saw in November. So let me speak holistically about what the overall policy would require, and then let me drill down on what are the key changes from November 22 to what you're seeing today. So first and foremost, this policy would say, as a statement of the commission, that your premise is you're only going to take up outside services as an exception to the rule. That the rule remains, you want to see clean boundary changes. So you're already creating this very clear signal to cities, districts, and landowners. If you come to us, it better have a very good reason to jump over the preferred annexation route. Separately, while some commissioners and staff might think these terms new and extended are self-evident, in practice we have learned that new and extended are not necessarily black and white. And so we've added some definitions to these terms, in particular with extended. And this somewhat goes to the Coronado Imperial Beach issue. What we have in this policy would say an extended use, whether it be water, wastewater, is only triggered, i.e. a city or district would only have to come to this commission to get approval on an extended use if there is an accompanying zoning change by the appropriate land use authority, right? So if the land use authority is taking some kind of entitlement action on their end to accommodate an expanded use of some development, going from single family to multifamily, going from commercial to industrial, that would be the trigger then to say to the applicant, no, you got to come to LAFCO and get an approval for an extended use. If it's just simply an ADU, well, there's no zoning change for an ADU. You don't have to come to LAFCO. So in addition to the idea of a policy statement saying when you want to see or when you'll take up outside service approvals, a policy of local definitions on key terms, new and extended. The policy also creates local exemptions, okay? And I'm going to come back to that in a bit because we have expanded on the range of what this commission would say are locally okay activities between two or more public agencies where you don't need a formal approval from the commission. But what has changed in this policy from what you saw in November are a couple of things. First and foremost, when we came to you in November, the discussion of the EO's approval authority wasn't really on our radar. Well, obviously the Palomar example put that on the radar. So what this policy would do is bifurcate the executive officer's authority. The executive officer would still be authorized to approve emergency out-of-agency service requests involving water or wastewater. However, anything else would just directly go to the commission. So, a failed septic, a depleted well, that would go through your executive officer. He or she could approve on their own. However, an issue with Palomar, an issue with an RCD, those would automatically go to the commission, and then by consensus, you would take action on those topics. I mentioned that we've expanded the list of local exemptions. So we've expanded the list of local exemptions to be quite expansive. So if you're looking at your handout starting on page 3, all of the following we are saying does not require a formal approval from LAFCO. Abandoned vehicle abatement, accounting and billing and payroll. And keep in mind, these are typically arrangements or contract between 2 or more public agencies. Building and code enforcement.
Are these the only?
These are the only local exemptions. Dispatch, grant writing, IT, legal, pooled equipment, material services, and training. That would be in addition to, again, what the legislature has already identified, which are any arrangements that were clearly established before January 1st, 2001, and then contracts, any contract between 2 or more public agencies where, again, the services are considered in exchange for something that's already being provided. Now, there's one key item that has been taken out of this October update that was in your November draft. And it's done so at the recommendation of the Special Districts Advisory Committee. So back in November, staff came to you and said one of the key issues that we're having in administering this code section is local agencies self-exempting themselves and not even coming to LAFCO and asking, hey, is this arrangement meet the threshold under statute? Mission RCD is the golden example where they were self-exempting and it turned out to be the wrong call and a very costly call because contracts had to be unwound. The original November version of this document made an explicit statement that I certainly believe is consistent with statute and practice, which is LAFCO decides exemption status, exemption eligibility. The special districts in particular, at least those who are appointed or elected to your advisory committee, have felt strongly the other way. And through effort over the last year, we just haven't been able to come to some agreement from your staff and the advisory committee on what would be a good workaround. So the result is the version you have before you does not have that provision anymore. There's no longer an explicit statement that LAFCO oversee the exemption status. Certainly there's some inferred implications, but we're no longer putting that in there. As you take up this item today, and I know that you're going to have some comments from interested parties, we certainly would benefit from the commission's temperature on the topic. Again, what do you believe is appropriate in terms of creating a guideline and kind of rules of engagement on the topic of exemptions? Do you want to be clear about who you believe should or should not be signing off on exemptions, or would the alternative, which is in the approach in this update, of just not diving into it and allowing on a case-by-case example or basis to proceed? So broad strokes, Chair Desmond, that is the update to my memory's ability. Hopefully, Carol, if I've missed anything, you can jump in and supplement. I know we have some speakers and staff is ready to discuss and hopefully get some good feedback, Chair Desmond, so thank you.
All right, Keen, thank you. That was very
Very good explanation of what's going on here and what's before us. Do we have questions on the process? Not opinions yet, because we got speakers, but you got a question, Mr. Willis?
Yes, King 3A, it seems to be always been brought up to me, and is that one, you've got a line through it?
Yes.
Okay, so is that one of the suggestions of the advisory committee? Because
Yes.
it seems like that was far-reaching, and it seems like it's making it too heavy-handed in terms of our jurisdiction.
Well, I certainly would share, Commissioner. So on the handout on page 2, the original 3A is the source of the contention with the Special District Advisory Committee. I wouldn't refer to it as heavy-handed, but nevertheless, I would agree that that's the source of the contention.
Okay, so you feel, so the issue is going to be how strongly we should oppose that.
What?
So the question is, does the commission prefer that to be in or out? Right now, it's out.
What are we talking, what
So
are we
through
talking
the
about?
chair, we are discussing the applicability on page 2 of the handout on the track change version. The original 3A that has now been struck previously said all statutory exemptions under the code section, as well as any local exemptions, is the responsibility of the commission.
I think that should stay in.
That's struck out.
Yeah, I know, it is struck out. I think we need to be clear, but go ahead.
Did you take this to the the city's advisory committee as well as the special
We
districts?
did. They were less engaged, and so this was not a heartburn for them.
And one other question about, I kept hearing from the special districts that this conflicts with California statutory law. Is that something that is true or false?
I disagree. I think it is 3A as drafted is consistent with statutory law.
Thank you.
I guess I would lean towards, let's be as clear as we possibly can, as opposed to leaving it kind of out there in the ether. I think it's better if it's clearer moving forward that it's a responsibility. It's either their responsibility or our responsibility, but just leaving it hanging out there I don't think is the right answer for this. I'd rather see 3A left in there, and you're still going to be taking public comment afterwards, but you could, it depends on whatever this commission decides, but Mayor White, I see you moving around. Do you want any?
Yeah, I'm listening.
Okay, well, I don't know. That would be my recommendation to leave 3A in there.
I'm sorry.
That's okay.
Okay. Clarification, when it says the commission would make that decision, is that the EO would make that decision or the commission would make that decision?
So through your EO, the executive officer would make the decision, although there was language, there is language in here for anyone to take an appeal directly to the commission.
Then it seems like 3A should state that. It seems that is misleading when it says go to the commission, because we have this huge other issue about the EO versus the commission making decisions, and so it seems like 3A should specify one way or the other, because that's a totally different question.
Okay.
Well, how about if it was put in there that the responsibility of the EO and can be appealed to the full commission
Perfect.
Okay.
for 3A? Is that everybody nodding heads on that?
No, I.
No? Okay.
I'm in favor of what was underlined, the commission shall emphasize the point of delivery, and leave out the A. That
All
was
right.
there in November.
Well, we can take a vote on that later, I guess. Yeah, Supervisor Anderson.
For as long as I can remember, the RCDs have always had a turf war, and I think that being more explicit would be helpful to them, and it keeps them in their lane. I spent 10 years on the RCD. This is not our first rodeo. Every year there's some issue. So the more defined, the better, in my opinion.
Okay. I've got some other comments as well. We'll come back. I want to get the speakers. Hear from the public right now. Oliver Smith and Tom Kennedy.
Morning.
My name is Oliver Smith. I am a member of the LAFCO Special District Advisory Committee, and I am the director of the Valley Center Municipal Water District. Absolutely, the last meeting of the SDAC, we voted pretty much overwhelmingly to delete 3A. But I'd like to point out some comments that were made during that meeting that are not reflected currently. One is several committee members voiced that they were inherently against any additional oversight by the district, so I want to put that out there as I'm one of them. So the consensus was that LAFCO could be setting itself up for a death by 1,000 paper cuts, requiring approval of all OSAs between districts. The sheer number of agreements, the development of LAFCO expertise for each type of agreement, and the resource bandwidth available would make it difficult to judge the advantages or disadvantages of each OSA. In the case of Valley Center, we have an agreement with Fallbrook for a Vector truck. A Vector truck is a vacuum system for cleaning up wastewater spills of any kind. Fallbrook has one. They don't use it all the time. We do not have one. We made an agreement in November of 2018 to be able to borrow their truck at a fixed fee when we needed it. That kind of agreement, I don't think, needs to rise to the level of LAFCO. It's two adjacent water districts that are sharing equipment. Many OSAs that would benefit from both parties that start them would go by the wayside if it was too much effort to go through the process. Good ideas would go by the wayside. Third, OSA should not require LAFCO to be involved unless a concern is raised. Only if one of the parties has an issue would it be the task of LAFCO to intervene and, if necessary, arbitrate your concerns. That's what you're here for. One idea was to have the LAFCO review the relevant agreements during municipal service reviews that are about every five years. If it is decided that LAFCO does need to review the OSAs at the time of the agreement, that there should be an agreement size or resource or cost threshold for submittal. Again, to get away from the 1,000 cuts. Thank you for your consideration.
All right, Oliver. Thank you. Mr. Kennedy.
I'm back.
Yeah, I thought you retired.
Yeah, well, I'm just not going to be working at Rainbow anymore. Retirement is far off. I think obviously this is a long history of this one. As some of you recall, this was a proposed legislative change 3 or 4 years ago that received statewide interest in oppositions from CSDA amongst other people. So you find yourself in a difficult spot. I think that the orderly management of boundaries does require LAFCO to be involved in this process at some point. But your special districts and presumably the city members are also granted a specific exemption that they have the authority under state law to self-exempt, right? And so that is where the pickle is, because they don't like giving up rights they think they have. Some of the umbrage you hear is from agencies who feel they have a right under state law that LAFCO is now taking away. And nobody likes that. So you find that to be a problem. But I do agree that with staff that there needs to be something done other than the wild, wild west that we have now. So what I proposed at the Special District Advisory Committee that didn't come through as clearly into the staff recommendation was that the policies say that the executive officer and the commission has the authority, and you do, to evaluate and approve or deny out-of-agency service agreements, but that that would be done at each 5-year municipal service review. But that in the interim, if some agencies are planning to get into any of those agreements, that they'd be wise to come seek the advice of the executive officer prior to the MSR so they don't make investments in pipelines or facilities or equipment or get themselves tangled into an agreement that gets unwound because it's found by LAFCO 3 or 4 years later to be illegal or not appropriate. So I thought it was like a way to encourage people to do it without the death of 1,000 pinpricks, because there's a bunch of us who will have one parcel here that I can serve that Fallbrook can't, or Oceanside. I serve some parcels in Oceanside that they can't serve. Fallbrook serves some of ours. And those are easy ones that will always be approved by the EO, and hopefully at the next MSR, the spheres of influence be adjusted to make those no longer out-of-agency service agreements, right? And so on those things, they could be just a cleanup. When you get into situations like what happened with the RCDs or the healthcare districts, you know, those are ones that are high profile and whatnot, and while they may have an opinion under state law that might differ from your legal counsel, that they have the right to self-exempt, this would at least make it clear that, yeah, go ahead, do it, but you're doing it at your own risk, because we might pull the rug out from under that when the time comes. So I think that if you go along that path, it will allow special districts to feel like they're still holding the power, but to remind them that whatever decision they make are subject to review by LAFCO, and they would be well advised to come seek consultation prior to entering those agreements. Those are my comments. Thank you.
All right, so that probably brings up a whole bunch more questions.
I do have one.
Go ahead.
I do have a question.
It's easy, everyone would do.
Yeah.
Is there a cost for those special districts to come and just ask about the exemption?
No.
What kind of information do they have to provide you, though? It's not in
Typically,
here.
and this is practice, right? So most do come to LAFCO and ask, is this exempt or is it not? And generally, it's a phone call, it's an email, and they describe the situation.
Okay.
And 9 out of 10 times, staff agrees. The 1 out of 10, though, are important. That's how Palomar ended up coming to you, because they thought they were self-exempt, and they came to us and said, you actually have to go through a LAFCO process.
Can somebody self-exempt themselves into somebody else's territory, and that other territory doesn't agree? But I guess the encroacher says, well, I'm self-exempted. I'm going to self-exempt myself so I can go in your territory. That is what Mission Resource Conservation District is doing.
Yep.
So how do we?
that was
But at the same point,
Palomar.
we don't want to. If somebody wants to share a truck, we don't need that coming here. So how do we prevent? I don't know. So if we leave 3A in here, if they want to share a truck, do they have to come to you and ask for permission?
So, and that's a great example. So under the local exemptions that we've carved out, one of them on page 4 is pooled equipment purchasing. And we probably would want to amend that to say pooled equipment purchasing and use. And so under use. And so under the local exemption that we are suggesting you create with this policy, they would be exempt. They would not need to come and ask for formal approval from LAFCO. Similarly, if they had a shared consultant to do vehicle miles traveled inventory, that would come under the auspice of services. Certainly, legal is common. We use county council on occasion, so we would, have a reason to have such a provision in there.
Well, how onerous would it be if we left 3A in there to this agency? Are we going to be inundated, or, I mean, it's already in there, isn't it?
What was the concern? Would you reiterate the concern that the Special District Advisory Committee had?
So as I think Oliver articulated, this idea that by having this policy and the potential for LAFCO to say, no, you have to get approval, that we would be discouraging cost-saving opportunities among local agencies. That at least is the articulation of many at the Special District Advisory Committee.
But isn't that what we want? If you're going to do an out of service, we want them to come. We want them to know that they need to come. I think the issue with RCD, they didn't know.
Well, once they knew, they still said we could self-exempt. So they were a very good poster child for this policy to come to you.
Well, they've taken care of that issue now.
Well, doesn't it, if both parties agree, does it have to come to LAFCO? It would seem if both parties agree to the exemption, that it should be okay. It's the case of when one doesn't agree, then they come here. But if both parties agree on sharing a truck or whatever, they're sharing that they don't have to come here. Is that right?
But isn't that part of the exemptions in 56-133?
Well, the issue about that question, if the parties agree that
Both
they're
parties agree.
exempt, they shouldn't have to come here. Let me give you an example of that. If two people agree we're going to engage in illegal activity, just because they agree doesn't mean that now it's legal. So that's the touchstone.
Okay. What do you got?
What about other LAFCOs? How do they handle that out of agency services?
So I can speak to 3 off the top. So Orange, Marin, and Napa all have similar policies that reflect what was once 3A here.
Does that mean all the other ones?
No, well, it's not that they don't have it, but many don't have, like us, we don't have policies on it, it's practices. And I would offer up to the commission, your practice is to be the decider on exemption eligibility. What we were attempting to do is make that practice into formal policy, and that's where we've had this healthy but nevertheless pushback from the advisory committee.
Just to be clear, those LAFCOs that you cited, they have a written policy.
Yes.
Which is what we're trying to do.
Yes.
Okay. And I guess we're not making any decisions today. This is more for input for him to bring back. Yes.
I just wanted to, it just seems like the wording is too broad. I think that's what the advisory committee is concerned with. That we're going to expand to beyond what is necessary in these situations. So I think they have trouble, I'm sure they have trouble with the wording on this.
Well,
Are we still talking about 3A,
Yeah.
Jerry?
I don't think we want to we want them to collaborate, and we want them to do that, but there's going to be instances that come up where exemptions under 56-133 need to come, I guess, to the executive officer at this point in time, and then you can appeal it to, we don't want to be overburdened with every little thing either. So I guess that might be a recommendation from this commission to, yes, we'd like to have the language 3A in there, but don't make it so onerous that every time they want to share a broom or something like that, it's got to come here.
I also want to note that 56133 talks about the extension of services. So if there's a shared piece of equipment, but a special district only uses that shared piece of equipment within their territory, this is very fact specific, but that it may not trigger 56133 at all because it's not related to extending services beyond the territory. I'm not saying that would be the case always. I'm just saying it is very fact specific, and so some things that are shared costs may not necessarily implicate 56133.
So is the commission okay with leaving 3A in there, but maybe, I don't know if the word is softening or allowing agencies to still make decisions on their own, but if something rises to the level, it's a certain, I'm not articulating this very well, but I think we want to have it clear what has to be done, but it still allows them to operate without being overburdened by us.
But that's what the new 3A says.
I know, so I'm asking them to come back with modified.
Shall emphasize the point of delivery in processing the applicability of section 56-133. That's kind of your softened one that was crossed out.
Okay.
So was it the advisories, Keen, was it the advisories committee, was it their opinion that 3A should be left out altogether?
Special districts, yes.
Okay, that's my stance.
Okay, all right.
And I would go along with that too. But I do have a concern on one of these, or actually a real question, on the one only that allows the EO to make a definitive and a determination with no recourse back to the commission. And that has to do with water and wastewater. And I'm trying to figure out and I've asked my GM also, what emergency, health and safety would come up that wouldn't be taken care of before making an application. In other words, if you've got a problem with water or wastewater, you're not going to sit around and put in an application to the EO that say, hey, we need to be exempt because of a health and safety. And all of the septic that we get that, we meet every month. This document indicates that we can call a special meeting, but your septic system just doesn't fail today, and you need an exemption tomorrow. These are ongoing. So I'm trying to figure out what the thought process was. What kind of an emergency are you looking at?
So through the chair, so Commissioner McKenzie is making reference, if you look at page 5 of your handout towards the bottom, this is the carve-out that I mentioned. So right now, your baseline, in fact, your only policy on the topic of out-of-agency services in existing policies is in the job description for the EO, and it says EO is delegated the authority to approve out-of-agency services whenever a public health or safety finding is made. Here, beginning under subsection C of 5, so 5C, we are saying there's a carve-out where the EO's authority to approve those is specific to water and wastewater. And this happens twice, 3 times a year, where someone's septic system is either shot or just about to be shot, and they work through county environmental health, and they come to LAFCO and say, we need to connect to the closest collection system, or a groundwater source has become contaminated or is no longer providing adequate fire flow, they come to LAFCO. Under those circumstances, it's not a question of whether they're exempt. They are applicable to 56133. What we're doing here is saying you get a fast-track approval from your EO if he or she decides, yes, the documentation is there from environmental health, private contractors saying the house is no longer inhabitable. Everything else, though, under this bifurcation, if you start looking then at, D says all other emergencies, yes, they're emergencies, but they're going to have to go to the commission, and that's where the language is, the chair shall work on scheduling a special meeting as needed.
And your examples, though, aren't something that need approval from LAFCO instantaneously.
Under the law, they do.
Pardon?
Under the law, they do. A city or district under 56133 cannot provide new or extended services outside their boundary without coming to LAFCO. So even though it's an emergency case, they're still triggering this requirement that they're serving outside their boundary by contract, so they have to seek LAFCO approval. What we're doing here is memorializing practice that says, hey, if you've got a failed septic or a groundwater well depleted, within 24 hours, we can do the due diligence and get you an approval.
So is that then going to come back to the commission?
Under this, it would come back for information only.
So I think that's good that you get the authority to do that right off. I don't know. I agree with that. I think that's a good thing. I just have a question, and I think it's great what you've brought here before us, and in the emergency authority, particularly tied to wastewater and others, and the other health and safety ones. If we have to have a special meeting, we'll have it, and we can move that forward. No, one thing I do have a question on under, I don't know, my page 186, or it's page 2 in the staff report. Under applicability for the, this is where somebody can come, cities and special districts may request, I'm looking at 3B, a a no-cost determination from the commission, actually from the EO, as to whether any proposed out-of-agent services are eligible for exemption. So if anybody comes forward, they can get a no-cost, as you said, it doesn't cost anything to determination on the exemption. However, the applicant can, in 3BI, allows the executive, gives that authority to the executive officer. It takes away from the commission and gives it to the executive officer to make those no-cost determinations when somebody brings it forward. It does say, though, that then in 3B2I, that the applicant can appeal any decision to the commission. I would like to see a triple I paragraph in there that states also, if you do determine that this is out of agency is exempt, that the affected agency can also appeal. So in other words, if you make a determination that somebody can't, you are exempt, you can offer those services over here, and then if you deny it, the applicant can appeal. But if you appeal it, then the encroached upon agency should also have the right to appeal.
So any affected agency within that covers that service area would be given a notice?
Would be given a notice and also have the right to appeal the decision if they don't like it.
Okay.
Whether approved or denied.
Yes. Yeah. So it would, if it was denied, then it'd be the applicant, but if it was approved, then it could be either party have that opportunity to do that. And then the only other thing that I noticed bringing forward here is the we know your, what are they called? Your responsibilities. If we do change this language in here or adopt a new policy, that also reflects, I guess, in your responsibilities in your job description. I think there's a section there on rules. I think so. I want to make sure that we don't have contradictory statements about when you file an emergency or who has the authority for emergencies and how those are handled. Okay. So if I can, I'll try to pull this together. It seems like there's a consensus on I don't know if it's consensus or not, but we have differences of opinion on 3A within the commission about leaving it in or not. So I think it would be we've got people that say no, don't have it in at all, and we've got other ones that say yes, it should stay in because I think there needs to be. I'm on the side of it. We need 3A because we need to have clear, I think, decision-making processes so that it's not just kind of hanging out there in the ether. And I understand the special districts, they don't want to lose that authority or that ability. But I think if there's some way we can still have 3A and the agencies can still have enough authority on their own to where decisions that don't rise to the occasion can be handled locally, as opposed to everything has to come here. Is that, I'm trying to, is that sound, you go ahead.
I think
Ms.
that
Becker.
sounds reasonable, and I think that maybe what will happen in practice is that we might have more exemptions under the local exemptions. Maybe that we'll find that there's something that, we didn't realize, but that is easy, and we can add that in. So I'm in favor of that as well.
So that's what it sounds like, with the difference of opinion. Yes?
If we put the 3A back in, I've read these about 4 times just now, again, is there a reason to delete the underlined 3A?
No. So the new 3A was added separately in thought from the discussion of what the Special District Advisory Committee has brought up, and it goes to a bit of what Holly mentioned, which is the point of delivery. If you have a vac engine that you've bought with agency Y, but you're operating it within your boundary, well, then there's not a 56133 issue. So it's the emphasis on where is the actual service, even if it's the result of a contract in which, things can be contemplated, but if it's happening within agency's boundary, well, you don't have a 56133 issue. So the point of delivery was an important add separate to this discussion about who makes the call on exemptions.
Okay.
Okay.
So can we leave both of them? How convoluted would it be and confusing would it be to leave both of those 3As in?
I think there's no confusion. Other than the red line creates distortion for the
Tell me
eye.
about it, yeah.
The
I
Chair,
would go for that.
the thing that I keep hearing when I'm talking to other GMs and board members is, because of how this is worded, they have these shared contracts going on all the time, day in and day out, day in and day out, constantly, and they don't want that disrupted.
Okay.
They do not want that disrupted. They don't want LAFCO's authority expanded to disrupt that. That's what I hear.
Well, is there a way
That's what I hear Director
is there a
Smith
way
say.
to do that with 3A that still makes it clear, but still allows them to operate? I guess for these smaller
Yes.
ones, we don't want to, be honest with you, I don't want all those things coming to this board either, or this commission. So is there a way to still have the clarity of, I guess, the final say if there's disputes?
Well, I would offer up this. So again, the practice is, and from 90% of the cities and districts do come to LAFCO and say, hey, is this arrangement qualify for an exemption? And within a phone call, usually we say, yeah, it's exempt. You don't need to come to LAFCO. Or it doesn't even apply. 56133 doesn't even apply. So I do not believe 3A, the bringing back the original 3A, would inhibit special districts or cities from doing their shared arrangements just based on the track record of
It's already been
going through them.
It's already been in there. And they've been
But what
operating.
we can do, and I appreciate the commission's discussion on this, is further work on some language to A, make clear the process, and B, emphasize that the commission does encourage shared service opportunities. We're not looking to impede that. We're just looking to do our part in making sure that they're clean and there's no conflicts, because we are trying to avoid the conflicts. So I think I have good direction to put this back, put 3A back in, both 3As, if you will, and then go do another final round with the cities and special districts and articulate the commission's consensus, not unanimity, but consensus of what I'm hearing is that you do want to see an ultimate decider on exemptions. And I guess someone made this parallel, Chair Desmond, and I thought it made a lot of sense. Developers and applicants certainly can come to the county or any of the 18 cities and believe their project is exempt under CEQA, but it doesn't forbid or preclude the land use authority from their duty to decide yes or no to that. And in many ways, this is the same process.
Okay. So 3A has been in there, and they've been operating quite well without having any heavy burden. So leaving it there shouldn't really change things dramatically. I mean, they've already got these outside service contracts. Okay.
Quick question, though, and it's really simple. Application, when they call you up and ask, hey, is this exempt, there's no cost, but if it isn't exempt, then they have to fill out an application, and you've got the process here, and then there will be an application fee.
Mm-hmm.
And that'll be determined,
You have an existing fee schedule that contemplates the cost.
is it? Okay.
Yeah.
Okay. So you got clear enough direction here?
I do, and it very much
As clear as
appreciated.
mud.
And so,
You'll bring it back in December?
yeah, depending on when we can get the cities and special district committees to meet, but certainly our goal, sooner than later, to get this process wrapped up. So thank you, Commissioner.
All right,
for-
appreciate it. And I think,
So there's really only two changes then, the three As, and then the use, add that back to,
And then syncing up the job description,
okay.
responsible, and that triple I.
triple I to provide
3B.
notification to affected agencies.
So both sides can appeal.
Yes.
Okay, the affected and the applicant.
Got it.
On that. And so we'll have a chance to vote on this in December. All right. All right, where are we? 7B, I think we're on right now.
Chair,
Yes.
I think we have an online speaker for 7A.
Oh, I'm sorry. Okay. Apologize. Thank you.
It's Brian Olney from Helix Water District.
Can you hear us, Brian?
Maybe online. Did he come back?
He's a GM for Helix.
Brian, can you repeat yourself?
Yeah, this is Brian. Can you guys hear me?
Yes.
Okay, thank you. Might be some technical issues going on. Anyways, appreciate the opportunity to comment and the discussion. I think there is some confusion on the process of how this will work. I'm also speaking on behalf of Joe Scazziti, who's on the Special Districts Advisory Committee. He's unable to make it today. But we do have concern in terms of the added authority in terms of making the final exemption, although as the executive officer mentions, it may be practice. We have concerns on overreach and the red tape that this causes in terms of the day-to-day operations that we do. There's hundreds of these agreements. I understand that the commission is saying they don't want to see these coming to the commission, but in light of the policy being there, we'll have no choice but to come to the commission as it's written or through the executive officer on that. Our view of LAFCO is to promote efficiency in operations, and we're seeing this policy as completely opposite of that. It's another layer of oversight in government that we're going to have to go through for issues that don't currently exist in the water and wastewater agencies arena of operations. At a minimum, we prefer to see the policy move forward without 3A included. And if it does, we would like to see additional exemptions for water and wastewater agencies, specifically when legal contracts are in place between the agencies. Thank you.
All right. Thank you very much.
And we have one more speaker.
Oh, okay.
For Jose Martinez.
Hi, good morning. This is Jose Martinez, General Manager at Otay Water Authority, and speaking on behalf of our Board of Directors. I just want to echo the first and the last speakers' just comments on we'd prefer to see 3A not proceed, but if it does, enough broad exemptions that it allows those of us in the water and wastewater industry, which have a lot of these services that we provide, for the benefit of our ratepayers, to be very efficient, minimal bureaucracy, minimal kind of regulatory overreach. It's one of the few things when the legislature passed the original exemptions that I was actually, happy to see that it wasn't adding burdens. And so we would just like to see that continue, again, just for efficient use of day-to-day operations that most of us in the water and wastewater industry here go with, been doing it for years with no issues. So thank you very much for the opportunity to speak and for also just the lively discussion and hopefully ongoing discussion as it comes back to the advisory committees and to the commission. Thank you.
Thank you. Well, I just, one quick comment. Is that it on the speakers? This language has already been in there. And I guess what we don't want to have happen is somebody self-exempt and say, well, I have the right to self-exempt into your territory or into your district, and they think that's the end of it, and that's not. So I think that's what we're really trying to clarify. We don't want to take away local control. We don't want to, have everything brought here before us, but we want to have it clear that if an agency self-certifies themselves out of their district, that there is a final decision to be made on that, and it doesn't rest necessarily with the one agency that decides to do that. So that's really what we're trying to stop from happening. So we're not trying to get deeper into your business or anyway. So good luck with that, Keen.
Thank you, sir.
See what you bring back. Thank you. Appreciate it. All right, 7B. This is the informational report on the property tax allocations and exchanges with the county.
Michaela, please start us off.
Good morning, Chair Desmond and Commissioners. Michaela Peters, Analyst 1. If you'd like to follow along with this brochure, it's on page 193 of your agenda packet. So, Angie, can you put up my slide? So before the commission is the first of a few planned informational reports for this year as part of our standing practice at LAFCO to provide friendly check-ins on topics of interest that substantively tie into the foreground of your planning and regulatory duties to facilitate orderly growth. This informational report is a late arrival from last year's work plan and check-ins on the 1% property tax allocations and exchange processes in San Diego County and its relationship to LAFCO. And while a bit late in its scheduled arrival to the dais, the topic itself remains timely. Most notably, there continues to be a noticeable increase in interest from both developers and local agencies in how the exchange process works when it comes to syncing up with jurisdictional changes. There are probably a few reasons for the increased interest in the property tax exchange, but certainly at or near the top of the list is the swing we are seeing within the development community to redirect development away from the unincorporated areas and into the cities, which means, among other things, triggering property tax exchange negotiations under LAFCO statute. A very prominent and current example of this redirection involves the Otay Village 13 project. So with this context in mind, the informational report before you is in brochure format and hopefully provides a user-friendly primer on all things involving the 1% property allocation and the decision-making process to make exchanges among the local agencies. This includes LAFCO's role to determine the property tax exchange in certain instances like city incorporations and district formations, as well as prescribed negotiation processes along local agencies anytime other jurisdictional changes are proposed. Key takeaways are summarized on the second fold of the brochure, with several of them shown here up on the screen. And some of these include nearly 1/2 of the 1% in property tax revenue, or 47 cents of every dollar in San Diego County, goes to local school and college districts. Most of the remaining 1% property tax revenue, about 38 cents of every dollar, goes to the County of San Diego and its 18 cities. And another one, special districts only get about 3 cents of every dollar. And while the 1% property tax applied to land and structures doesn't change, the allocation among local agencies does. This is because every jurisdictional change that comes to LAFCO is subject to mandatory reviews and possible exchanges, and the fact the commission cannot act on a proposal until the review and possible exchange is completed. As mentioned, LAFCO determines the exchange, if any, when creating a new city or special district. All other jurisdictional changes are subject to a prescribed negotiation process. And a couple of these key distinctions within the negotiated tax exchange. Can you flip to the next slide? Include the County Board of Supervisors is responsible for determining the tax exchange for special district annexations and detachments, with the qualifier that the Board of Supervisors must negotiate in good faith with the districts. The county and cities have equal standing in the negotiated tax exchange process and statute. Master tax exchanges are allowed, and several of them remain in play here in San Diego County from the early 1980s, and with the qualifier, any local agency can request individual negotiations at any time. These master tax exchanges apply to most of the cities and provide anywhere between 34% to 53% of the county's take of the 1% to the annexing cities. And however, at least under current statute, the negotiated tax exchange process does not include a hard stop. If agreements are not reached through the 7-step process, they can simply restart until resolution. I will go ahead and stop my presentation here and invite you to go further into details on any of the items of interest to you. And we're seeking your feedback today, so including any requests to expand the scope before we finalize the brochure.
Okay.
Thank you, Michaela.
Thank you.
Any comments from any of the commissioners? Them. Commissioner Anderson.
I'm sorry, go ahead.
I didn't say that.
Oh, I'm sorry. I thought it's hard for me to keep track of stuff. Do we get a lot of requests for this brochure?
Well, the topic has certainly been of interest. So this is the first time we've actually created a standalone brochure. So it's in draft form now. The question to the commission is, if there any items or topics you'd want to further flesh out before we finalize and send out to local agencies?
And did we check to see if the assessor's office has anything that we could use?
Well, the assessor office certainly has a breakdown of the allocation. What no one else has is the exchange process. That's the domain of LAFCO, and that's really the emphasis of the brochure.
Thank you.
So this is not an action item, we're not voting, solely information.
Just your feedback.
And have the other agencies that are going to be receiving this, have they've had input?
Actually, good comment. They have not. And certainly, now that you brought that attention, perhaps we could do a notice to the agencies, or social media or otherwise. And but for the most part, it's a rather black and white take on the exchange process.
Okay.
And again, because of the way development is now steering towards the cities, it is a conversation that we're having with a number of city managers these days.
Okay. Well, maybe if there's, I think we reach out to them, and if there's information they would like to see that'd be beneficial to them, or it's brought up in a certain way, I think that'd be my only request.
Mr. Chair, I would also suggest reaching out to the assessor. He may have a brochure that's already here, or if he knew there was a need, instead of us reinventing the wheel, he does this every day.
All right. Okay, any other comments? Is there any speakers online? I don't see any speakers. Tips, Erica? No, okay. All right, that takes us to 7C. 7C, Holly, you want to kick us off briefly on that one?
Sure. Before the commission is a consideration of amending the EO's contract to bump up the compensation. Attached to the staff report is a chart of the compensation of EOs, LAFCO EOs in the Southern California area, and includes a calculation of the average compensation for LA, Ventura, Orange, and San Bernardino. And, with that, the EO Compensation Committee did meet in August, as noted in the staff report. And you, Chair Desmond, I believe, are the only member of that compensation committee that is present today. So I'll leave it to you to discuss the recommendation.
Well, thank you. Well, thank you very much, Holly. Appreciate that. And Keen, the committee did meet, and we had discussed your evaluation for the year, where everyone is very pleased in all of the things that you've done and brought forward, all the heavy lifting, and then even today in the presentation that you had to jump in and give was very clear and concise, and we appreciate, I'll let my colleagues comment as well, but there's a lot of comments on how accessible you are and how you easily explain things to people and to all the commissions, and I think even to the public as well, if you get contacted. So we really appreciate all the hard work and the heavy lifting that you've had to do, particularly just in this last year with the Tri-City and Palomar issue, the detachment issue, and even bringing this policy forward. So we really appreciate your efforts. And the committee did make a recommendation based on the table that Holly had referenced. This is in attachment 2 of item 7C. These are the salaries of the Southern California region, and we wanted to bring you up to that to the average at least for the so the recommendation is to the average of the salaries in the Southern California region by the committee. I will also make that a motion, and if there's a second, Commissioner Anderson. And do we have any other comments that commissioners or alternates would like to make? Ms. Becker.
Yeah, I just want to say thank you so much for your accessibility and your expertise and your neutrality on all the issues. I appreciate it. There's a steep learning curve in this commission, and so we really do appreciate you taking the time to explain these issues to us, and happy to be on board, and a lot going on this year, so thank you.
Thank you.
All right, anybody else?
Yeah, I just want to say thank you, Keen, for even with my phone calls on Saturday, and so, I always appreciate when you get back to when you let me know when you're busy. So I think you do an outstanding job.
All right, anybody else? Ditto? Yes. Ms.
No,
McKenzie?
I think Keene's done a very good job. What I'm impressed about this year is his hires, his new hires. They didn't have a LAFCO experience before. He has brought them on, tutored them, and taught them LAFCO to where their reports and their presentations are impeccable. I mean, they're very clear, very concise, and I'm totally impressed. And their ability to do that goes back to Keene's educating them and tutoring them and bringing them along so quickly. I'm impressed with them more than you. But I know you were the impetus for that. And the only other question I have is, hey, when you do new hires or you change positions, would you let the commission know? I didn't know that Dew was now an analyst until I read the report.
Absolutely.
So who's doing the graphics?
Well, Dew has many titles, and he
Yeah.
does GIS,
Okay.
IT.
He's our streamer.
Yeah.
Yeah, just as long as we know who's on board.
Mr. Mathis?
I just wanted to say, express my appreciation. You and I have had a long, close association, and I can't tell you how much I value that, and I found it very helpful. Good work and well-deserved.
Thank you.
All right. Okay, I need a break.
How about a roll call? How about a roll call first?
Oh, yeah, we got to vote on this thing, okay.
Good call.
Okay, that would have been not nice.
Aren't we done then?
Okay, now, we still have the Executive Commissioner's Report and a closed session item to do, but Eric, if you could do the roll call, please.
Commissioner Desmond?
Aye. What's that?
Commissioner Becker?
Yes.
Commissioner McKenzie?
Aye.
Commissioner Anderson?
Aye.
Commissioner White?
Aye.
Commissioner Willis?
A wholehearted yes.
Commissioner Mathis?
Yes.
So there's 7 in favor, 0 opposed, 1 absent. The motion passes.
Thank
Okay.
you, Commission.
Thank you. Can we take a 5-minute break and then come right back? Thank you. 8, this is our Executive Officer's Report.
Just quickly, 2 items. Commissioners, all of you should have a bounded copy of this year's local agency directory. Appreciate Michaela picking that up from Tammy, who remains on leave. And then sad but hopefully pleasant news, this is our last meeting for a while with Priscilla. Priscilla will be going on leave soon, and then, God willing, returning to us with another family member come February,
Very
hopefully.
nice.
So,
Some pictures.
Yes.
Okay.
You can have 3 donuts.
Have your donuts now.
All right.
And that is all. Thank you.
Oh, very good. Short and sweet. Okay. Commissioner announcements or reports or requests for future items or more meetings? Seeing none. No. Commissioner
You know
McKenzie.
I always have
I know.
something. No, 2 things. One, I just wanted to report real quickly on Cal LAFCO meeting that we had in revising policies on the legislative committee. The way it was written, we had to have 5 board members on that committee, and they had to be present in order to pass business. We've reduced that to 3. We have reduced the committee from 16 to 15. Our Cal LAFCO counsel is still on that committee, but he is now a non-voting member. For some reason, the policy had the council being a voting member. Not that it really made a difference, but
Wow.
anyway, that was one of the others
Weird.
that we did. And we clarified it and rewrote it so that you could tell, where the sections were, other than just one big page paragraph. And then I do have a question of our executive officer. A couple weeks, month ago or so, there was an article in the paper regarding the Port District. And my question is, why aren't we including them as a special district?
That is through the chair, a question that has been on our mind. We happen to see the same article. The short answer is, it's been a side project of your staff to look into it. We certainly have an opinion, but we haven't gotten to the point of bringing it to the commission. but perhaps maybe sooner than later we need to.
I think sooner would be better rather than later, because this was
Understood.
an issue that I questioned when Robert Berry was here, because I thought they were an authority and not a special district. And he indicated that, yes, they were, and he sent me the Enabling Act, and it does say that they're a special district.
All right.
But I guess at that time, the EO didn't want to tackle that question.
All right. Well,
We will bring back at least an informational item on that.
Okay.
Thank you.
all right. Thank you very much. Then now, no other commissioners or reports from anybody? Okay, so we're going to move back into closed session and pick up item 10A. This is, I'll let Holly, you want to call us out into the closed session?
Sure.
Please.
Yes, item 10A is conference regarding existing litigation, and this involves the San Diego County Water Authority versus San Diego LAFCO, and that's Superior Court case number 37-2023-36018.
And I just want to be clear in public that I sit on both boards. I'm a non-voting member on the Water Authority Board, so I just want to make sure I can stay in closed session.
Yes, you can, and my understanding is you have not sat in closed sessions for the Water Authority regarding this litigation.
I have not.
Correct.
All right.
Okay.
All right, if we could clear the room again. All right. Holly, could you
Yes.
call us out of closed session?
Yes, on item 10A, there was no reportable action taken.
All right, and with that, that adjourns our meeting. We'll see you next month in November. All right.